Welcome to Franklin County Board of Equalization hearings. Today is Thursday the 18th, 2025. There will be one scheduled hearing today. The time is now 10 a.m. and we will hear petition BE 2025-33 with parcel 115-180-110 owned by Robert and Catherine Morocco Smith. From the assessor's office, we have Nikki Morgan, chief appraiser, and Mo Rogers, the appraiser who's on the case. This is a residential petition scheduled for 20 minutes. The appellant and the appraiser will each get 5 minutes to highlight points of evidence they have provided. The last 10 minutes we will use for rebuttal and questions from the board. We ask that both parties that have any questions or communication be directed to the board and the board only.
Good morning. Welcome to the Franklin County Board of Equalization. Board members are Joe Christ, Charles Laird, and myself, Lexi Moore, is the chair, and our clerk is Jen. The board is a quasi-judicial body, which means having to do with powers that are to some extent judicial as those of certain federal and state boards and commissions. The board and the assessor's office are independent of each other, and our role is to review the facts as presented by both parties and determine the market value of the property as of January 1 of the assessment year. The law does grant presumption of correctness to the assessor's office, and the burden is on the petitioner to prove that they are incorrect. This hearing will be recorded and all testimony is under oath. Our clerk will now ask you to affirm your testimony by raising your right hands. You too. Sorry.
Good morning.
Oh, sorry.
Go ahead and raise your right hand.
Okay.
Do each of you who will be testifying today confirm that the testimony you're about to give will be the truth?
I do.
I do.
I do.
Thank you.
Following the hearing, the board will meet to weigh the evidence and make a final determination. We will issue a written decision to you, which you should receive within the next 4 weeks. And this decision is appealable to the State Board of Tax Appeals with a notice of how the appeal opportunity works written at the bottom of the decision. The board is in receipt of all documentary data provided by yourself in the assessor's office, and we have reviewed it prior to this hearing. The appellant will present his case first, and then the assessor's office will present their case. And you can begin.
Well, good morning. I look a little harried. My car wouldn't start this morning. I thought, oh, no, I'm not going to get there on time. So luckily, I didn't have to meet a police officer on the way. So a little bit of background. I am a certified licensed real estate appraiser in the state of Washington. All right, slow myself down. Breathe. When I reviewed the proposed increase in assessed value, I was a little astounded in that I've been watching it for the last couple of years, but even at that point in time, my feeling was that the assessed value was above market value, which I realize is not a term here. However, the world turns on market value, and so I did some comparisons between our property and other properties within our development, Archer Estates, as well as probably the nearest competing development, which is Spencer Estates, just down the hill a little bit. Homes are probably highly comparable. In between there, our divisions is Eagle Crest, which is far superior, so we didn't pull anything there. I pulled sales. First of all, there are no sales within the Archer Estates development ever that will support this kind of valuation. There's never been a sale in Archer Estates that's even close to $900,000, much less $972,500. Our home is a nice home. We have improved it. It has a swimming pool. It's an in-ground vinyl line pool. And so the sales that I pulled were properties of comparable quality and included pools. There were none in Archer Estates during that particular time frame. I also went through and pulled properties in Archer Estates that had sold and compared them to what their assessed value were when they sold, and they actually sold for less than their assessed value. Well, it's all documented here. I mean, I guess my main gist of the process is that as a citizen, I look at the values of the property, and I assume to a point that the assessed values would correlate to market value. In other words, what's my house worth? Is that what you're taxing it at, or are you taxing it at a number that's based upon the desire to gain taxes? I don't know. But the information I submitted in the packet you have really relates to market value and the sales of the properties that are comparable or within my development and what they're assessed for and what they're sold for, as well as the properties in the competing developments. I think the data supports itself. I know that coming from the assessment side, in fact, at one time I was chosen candidate to be the assessor in Yamhill County in Oregon, and I understand the processes that are varied from doing single-family residential for market value and selling, but there has to be some correlation between those values. You have to have some common sense to saying, okay, well, it's going from up to $972,500, and there's no data that I can find that supports that kind of valuation. And I think I'll leave the data here. I mean, you've read it, you looked at it, so anything more I have to say is just kind of chatter. So, thank you.
Thank you. How close to time?
There's about 1:12 left if you want anything on the record.
Well, just that I hope that you'll look at that from a point of view that I strongly feel, and I think most of the people in this community will feel, that the assessed value should be related to market value. In other words, if you own a home and you would assume the assessed value is going to be close to, or quite often in most places I've been, below market value. But this one is substantially above. Thank you.
Thank you.
Assessor, would you like to start your time?
Yes, thank you. Good morning. After detailed analysis, the assessor's valuation of true and fair market value stands at $972 and some change. All the data and 4 bracketed sales brought to the appeals board will support this conclusion of value, and we respectfully request that the assessor's value be sustained. Exterior field evaluation on October 29th, when I met with the petitioner, did not discover any extraordinary conditions that would change assessed value. Our model was working, and it was working well within the appropriate range to value. Now, the appellant spoke about the different estates, Archer Estates and Spencer Estates. And these estates, as he knows, because he was originally going to purchase in Spencer and then he ended up in Archer, they're very similar. They're very comparable. And though he is speaking to Archer specifically, he hasn't found sales that are over 1. There are many sales within the Spencer Estates too. So the sales are there within the neighborhood, the competing neighborhoods. Now, these Spencer and Archer both have similar positive and negative location characteristics, lot sizes, quality, age, design, etc. The 3 sales that the appellant provided originally, before I got his packet, they were all well outside of Archer Estates neighborhood. They were 2.6, 3 miles away. They did have pools, but generally speaking, pools, solar panels don't make it appealable to the market for a reason to sell. People generally don't buy on pools or solar panels. So those were not considered as important components of the property to make sure they were matched because they could be adjusted for. All of our sales are within a bracketed range of his assessed value. When he originally talked about cul-de-sac influence and other influences. I looked into all that within my packet, and I couldn't find any reason that they would make adjustments that were extraordinary. Everything seemed within the range. Oh, thank you. And so these are just some pictures of his property. It's very nice, good quality. There's the pool the appellant spoke of, the general sketch. He was concerned about the temporary cul-de-sac. I added that in my packet. And basically, overall, when I looked over what the appellant brought, he did bring a lot of statistical data, but all of it was within an opinion range to value. There were some that he was requesting, and I don't have the packet. I loaned it to the petitioner because he didn't have his with him. But as I recall, in his packet, you will find he compared some assessed values to assessed values, and that's not a sale. We are going to assess at market value, and we can only consider actual market sales, not assessed values. So in that packet, I do remember seeing that, and we're unable to consider that. He did, after speaking to me, bring 2 additional comparables, as I remember, and one had an ADU. They just weren't nearly as comparable as the 4 bracketed sales that I brought forward. Overall, with respect to the petitioner, I do feel that all of our data was well bracketed and supports the assessed value. And I rest there.
30 seconds left. Anything else?
Just that our model was working, and it was working well within range.
Board, would you like to start your questions?
Yeah, we now have 10 minutes for rebuttals and questions, so if there's anything, we can start with rebuttals if there's anything that the assessor's office said that you would like to rebut, and we can have some time for that, if you have anything you want to add there.
Okay, rebuttal. I would really like to review sales that you have submitted. You said you submitted 4 sales from the county's perspective?
Correct.
I have never seen those.
They were emailed to you and delivered to your email address. That's the packet here on the,
I got everything you've emailed to me, and I don't see any sales listed. I've never had a chance to review any sales. Okay, I haven't seen them. Nope, never got this. Okay, there's my subject. Well, that's
I
interesting.
believe your wife was in the hospital when I sent those to you.
She was, okay. Well, with comments as fast as I can, all these homes are definitely newer. They're all, in Spencer 2, the construction level went up in that second phase versus the first phase, which is comparable to Archer. The second phase has superior properties. Some of that development runs closer to the river, and the lots are substantially higher, so it's increased their values. So I'd love to have time to review them, but obviously I don't. One of the reasons I utilized the sales I did with pools, and I also, something that's mentioned, they were all also included above half-acre sites, which are comparable. As far as the quick comment about the cul-de-sac, it's in the packet. It is a temporary easement. It does restrict, I don't have any street parking because of that easement right there. And also, it is the only cul-de-sac in the development, and every FedEx, every USPS, every garbage truck, every landscaping company in the world turns around in my cul-de-sac to get access. So the traffic is substantially higher for 4 houses in that development than anywhere else in the development. It's temporary. It's only been there since 2005. So we bought the house in 2015, or built the house in 2015, and not 2015. So it's been there since that period of time, and until a school gets built, it's going to be there. So how fast do I go? She mentioned the comparisons I did to assessed to other properties in there in the development. The actual comparables I made as an addition were to show that what the properties sold for compared to their assessed value. So each of those properties sold below their assessed value. Those are, let's see. Okay, where am I? Okay, this would be page 2 of 3. The top, there's 4 properties, Whetstone, Quiver, Easton, and Rock Creek, which sales priced at below their assessed value. And all of them, it's, to state that the model's working, well, that's a really nice, gorgeous statement, but maybe the model's not 100% correct. I just can't justify a market value. I've been appraising for a long time. I've been appraising over 40 years. And I understand market value as well as any appraiser in the state. And I just can't justify a market value of that property of $972,500. It just does not make any sense. And what I see here, you've got a comp sale at $875. You've got one at $834, $849, and then you have one at $629, and then you have down in Spencer at the high-end development of number 2, one at $1,287,000. Boy, heck of a range. You've only got one sale that's above $875,000. One, and all of them are below that. So to base market value on one sale,
Mr. Smith,
yes.
sorry, I want to make sure and give, I know the board has a couple questions, and I want to make sure
Okay.
Mo has some time for
So
those.
I guess I can terminate. Okay.
Yeah, sorry.
Thank you. Thank you.
Yeah, I had a question. When you purchased the property, was the house already built, or
No.
did you? Okay, were you aware that there was going to be a turnaround at that location?
There was a cul-de-sac in place, and actually our neighbor across the street, assuming that they actually built all the way out to the street. Let me rephrase that. It was straight, okay? And then construction started. We were the first 2 homes in the development, and our neighbor actually built out to the property line, and the city made him, or the county at that point, told him to remove half of his driveway because it's in this now cul-de-sac.
Okay, so you were aware, and is there an expectation that this would eventually be removed?
Yes, it was supposed to be. It is a straight access to the future school property.
Did the builder give you compensation for compensate you in any way, reduce price on the property or some benefit, recognizing that there's a cul-de-sac and that you wouldn't be able to use that area?
Documented, no. Verbal from the builder and the realtor saying there is a temporary easement in place. No idea of how long temporary is going to be.
Okay. Okay. That's all the question I had.
Do you have questions, Charles? Would you guys like to take a little bit of, how are we on time, Jen? Sorry.
3 minutes, 30 seconds.
Do you want to give a little bit of time for rebuttal?
There were 23 sales total within the neighborhood boundary. So we did have plenty of sales to pull from within the model for evaluation. And so though this packet only brings forward 4 sales, there were actually 23 sales within that neighborhood.
And they are all included, pages 20 through 23. So the statistical model, I mean, she speaks to it, but she also provided evidence for it. So it's important when you're looking at the sales prices compared to assessment to remember that the assessed value is based off of January 1st of the year. So if you're looking at sales that have happened after that date, I mean, we do expect the market to continue to move, right? It's not a steady market right now, nor it has been. So we're going to look back at the sales that occurred just prior to the assessment date.
And within the appellant's response, he also stated that he understood that the market did rise in 2024 and that this value is in 2024, from 2023 to 2024.
Was there a time adjustment in 24 in this neighborhood?
No.
No, okay.
Shouldn't be.
No, you can look at the trend line here noted on this page. So the actual trend line in the graph in the middle is the market movement. So our assessed values are set on January 1, and then the sales were trending a certain direction. You can see the trend line for our ratio is trending down, which means the market's actually moving up. If our ratio is lower, that's our assessed value compared to purchase price. So all through 2024, sales prices were going up, and our ratios were going down throughout the year. So we could have applied a time adjustment, an increase over time, but we did not.
Can I give a quick response to that? In my packet, you'll see a Pasco Annual Housing Statistic Report that was developed by the Tri-City Association of Realtors, and the market is flat for 2024. There was the average sold price and versus the median sold price did not, varied less than a half of 1%. So there is no rise in market value through 2024.
Which may be true for Pasco, but this is specific to the subject neighborhood.
So it's specific to this neighborhood, not
Correct.
town overall. I think that was my only question. Do you guys
No. Got the information here.
have- Okay. There's like a minute or something?
30 seconds.
There's about 30 seconds if anybody has any final words, otherwise I can wrap it up.
I'll let the esteemed colleague go first.
Just thank you for being here. I really appreciate all your efforts and the board.
Thanks.
I'd like to thank the board also for their time. I wish I hadn't been so rushed.
5 minutes is short.
It's, I did hear from my colleague when I started this process that there seemed to have been a lot of appeals from the Archer Estates development, which tends to lean to me that says, wonder why. So with that, I'm done.
Before the record is closed, I would like to note on record that the appellant's evidence was submitted 3 days after the established due date, and pursuant to WAC Code 458-14-066, the board may accept late filed evidence when appropriate. The appellant indicated due to a medical emergency, the assessors and the board agreed to accept the late filing evidence on record. This concludes the procedural record for this hearing.
Thank you.
Thank you.
Do you need this back?
This can.
Yes, please.
Yeah, sorry, I still have. 2025-33, parcel 115-180-110, owner Robert Smith and Catherine Morocco Smith. A final decision will be received by you within 4 weeks, and again, that decision is appealable to the State Board of Tax Appeals with written notice at the bottom of how that process works. The time is now 10:23.
Ms. Chris, do you need this back for your packet? Or can
Welcome back. Here are today's decisions for the Franklin County Board of Equalization regarding petition BE 2025-33, parcel 115-180-110 for petitioners Robert L. Smith and Catherine S. Morocco Smith. The board decided to sustain the assessor's value of $972,500. This concludes the hearings for December 18th, 2025. The time is now 10:57. The board is now adjourned.